key, wake up. The key, wake up. The key, wake up. It's incredibly pedantic to want a witness list when you have the witness statements.
Had 2 speeding tickets in January that were both dismissed because of no witness list being supplied. So we had, under those basis, they were both dismissed because they failed the 2 requisite requirements.
What I would say is twice extremely lucky and once not.
We were very pleased, I will say that, Your Honour.
This time.
I'll stand for His Honour the Judge.
Morning.
Morning.
And I'm going to be seated. Following the matter of Tony Adams to courtroom 3.
You're representing yourself.
Good.
I'm here as Mackenzie Friend, Your Honour.
And is this matter ready to proceed?
Yes, sir. Police are ready to proceed, sir. If this matter does go ahead, though, Your Honour, I do have a mode of evidence application to make in respect of one of the police witnesses, sir. If I may have the memorandum.
Excuse me, Your Honour, may we ask, this today was supposed to be for a pre-trial application hearing. At least that's what we have been made aware of.
I can't agree with that. What appears on the file, at least, is that it's set down for a judge-alone trial.
We actually have the email from the District Court here telling us it was set for a pre-trial application hearing for 4 hours. I questioned why 4 hours for a pre-trial application hearing. They couldn't tell me why.
It's the pre-trial.
Your Honour, I believe a stay application was provided, was
I have this.
submitted by the district. The correspondence that we received to say that it was for judgment power, managed to quickly prepare our file with anticipation of a judgment trial proceeding. So, in any case, police are ready to proceed.
If I may clarify, Your Honour, on the 3rd of February we filed an application for the stay dismissal. We received no notice of opposition as per District Court Rule 7.171A. We then, and also on the 9th of November, when we were in front of Judge J. Forrest, last time we appeared, it was set for the 25th of May. After filing on the 3rd of February the application for dismissal, it was then changed to the 18th of April. Then we were notified on the 17th of April that there were not enough judges to actually adjudicate, so it was put forward again to the 25th of May, and then we were given today's date for a pre-trial application hearing. It states that very clearly in the email.
What I would say to you is that having filed a stay application, that should obviously be heard before any evidence is heard.
Of course.
If this matter proceeds, we'll deal with that first.
We've also submitted an affidavit from Mr. Adams and also a bundle of submissions in support of the application for dismissal. Hopefully that they were sent late last night to you. I have copies here if you need them. On the 9th of November, Judge J. Forrest made a Section 30 order under the Criminal Disclosure Act for full disclosure to be supplied within 30 days. We received nothing until May this year, almost 4 or 5 months after the expiration of that Section 30 order. So, yeah, there's been quite a few errors.
How long do you think the state application will take to get?
Pardon me?
How long will it take to deal with your application to the state?
I would suspect no longer than an hour.
And if the matter then proceeds to trial, how long will it take?
Well, we haven't come prepared for a attended hearing today because we were just under the understanding it was a pre-trial application hearing, so we haven't even listed his wife as a possible witness or there onwards. Still waiting for disclosure, still waiting for the YouTube video to be supplied that was listed in the third bundle.
Okay, just take a seat and I'll try and work out what's happening today and whether we can deal with you.
As the court wishes. Thank you.
So the matter was called in court today?
Yep. Yep. We were going back already 45.
Oh, okay. Yeah.
But our question was, the judge is saying that it's set for a judge-alone trial today. And I said to him, well, we're under the understanding that it's a pre-trial application, because here's an email from you guys. Reschedule pre-trial application hearing. And he's saying, well, no, it's a definitive hearing. I'm going, well, no, it isn't. We're here solely to do with the pre-trial application. So, because it was, we filed a dismissal on the 3rd of February, got set the 18th of April, you guys didn't have enough judges, then it got put to call over. So I'm thinking that's why it's got mixed up as a judge-alone trial instead of a pre-trial.
It's going to be called back at 11:45.
Yeah.
That's correct?
Yeah.
Okay.
And we'll deal with the pre-trial application today.
When it got called at the first time, it was to, So it was a call through just to see what's going to go ahead and what's not going ahead. So I think it was just a short time to explain what was going on. But when you go back at 11:45, that'll be your time to.
Sure. Well, we can show him that anyway, just to say, well, look, that's why we're under the impression it's a pre-trial. Yeah. Because he disagreed with us and says, no, it isn't. And I go, well, we've got the email to say that. So.
Well, if you do show him that, because that would be on file.
It's in the bundle of submissions we actually sent to you guys last night, that whole thing. So that bundle of submissions and affidavit via email to Manukau District Court and to Manukau PPS. But this is for that's for another man. Pardon me?
Manukau Jack?
No, we sent it just to manukau.dc.
Okay, so it wouldn't have been based on file.
Yeah.
You submitted. So
Yeah.
He hasn't seen anything that you've submitted.
No, but we've got copies here for them if they want it, so I can give that to them. So, but I'll hand that to the judge when we go back.
Yeah. So when that'll be the time to discuss it with the judge.
Okay.
At 11:45. You're the attorney Adams. You're the McKenzie friend.
Yeah.
You are assisting him in the court.
Yeah.
There's no other lawyers that you have with you.
So.
If you do find that you need further legal advice, there are duty lawyers that are here. If you just want to reconfirm anything,
We might try and rope one in before 11:45.
11:45. I'd literally get my petition just so that you've got a bit about what you're presenting to the court today.
Or we can at least instruct them to hand these to the registry and to the other party anyway. So.
In the meantime, I will go back and find
So in regards to this, for the 12th of January, dismissed, the matter was dismissed, it was just a speeding ticket. The police failed in their duties of disclosure, so it was dismissed.
Did you get to speak to the prosecutor at all? Do you know who the prosecutor in court?
For up here, today, for this matter.
So you can speak to the police prosecutor?
I don't know who it is.
Okay. Tony Adams, and you sent it to the Manukau DC.
Oh, you haven't signed
Yeah.
here? Oh, you have to sign here?
It's a bundle of documents.
Yeah, there's a bundle of submissions and there was an affidavit also filed last night.
Okay. Usually, okay.
Like I say, we've got copies of these.
Yeah, no worries. You can always hand up a copy in
Exactly.
court as well.
Yeah.
But I'll hand this back to you. But I'll just quickly.
So this one, we're just after the transcript, basically, or the document of finality, saying that the matter was dismissed because.
Judgment. Oh, okay. So this
Separate matter.
document here is an application.
Yeah, that was just an application for the transcript. We did the.
Did you file this?
Yeah, we
back
sent
in
it.
18?
Yeah.
Did you receive it or anything?
No. Ironically, we sent one on the 17th to Hamilton because he had another speeding ticket in Hamilton, which also got dismissed. Same reason, no disclosure. They didn't supply us witness lists.
They dismissed this application or something because this application is requesting.
No, the matter this was dealing with, the CRN number for the speeding ticket, that was dismissed along with one in Hamilton. At the same time as we required on the 18th of April for this matter here in Manukau, we also asked Hamilton for theirs. With Hamilton, we got their document of finality, same as this, that we're asking for. They gave us it within 8 days, which is why we're questioning after now 2.5 months, why haven't we got like a 2-page thing saying matters dismissed? Because we just want it for reference to... Yeah, the transcript. Literally, it was 2 pages from Hamilton, and it would be the same here.
So this document here is
It's a request
you
for the
asking
transcript.
for the transcript
Exactly.
for what's happened here.
Yeah.
Oh,
From the 12th of January when we
filed
appeared.
here on the 29th.
Oh, he's just taking a copy of it today.
Oh, okay.
Even though
this,
it's...
so
Yeah.
that's your copy, so this is for the court.
Yeah, the gentleman over there
So
just
this
took a
is for us to
photocopy for you
process
guys.
now.
Yeah,
Okay.
in case you didn't process the last one.
Yeah, well, I'm not sure.
We just need the document because it just helps in further cases, so we can show that it's a pattern of behaviour of the police not supplying disclosure. The prerequisite requirements aren't being met, so...
Okay, so this is asking for the transcript of the 12th of January. Is that right?
Yes.
12th January?
Yep.
Okay. That happened here at Manukau?
Yep.
Okay, so this can be processed. I can process that
Sure.
today. And in terms of your question about what the type of hearing is today,
Yep.
do go back into court, make sure you're there at 11:45 and you can but I would recommend that you speak to a duty lawyer as well. Just get some little bit of advice of what you're going to present to the court today, and also speak to the police prosecutor. So at about 11:30, they might just, because they go on a break at 11:30 and then they start back up at 11:45. So between that window, the prosecutor will either be hanging
floating around.
outside courtroom 3, just have a chat to him about, hey, look, I'm under the understanding that today is a pre-trial hearing, but judge is saying, Jack, what is going on?
Yeah, well, the judge already asked us how long it will take for to have the pre-trial dealt with, and I said an hour.
And
but
also there might be some kind of resolution that you can come to.
yeah, they can dismiss it.
Yeah, so that's why you can have a chat to the police prosecutor. Like,
Sure.
just say, hey, look, listen, look.
Well, see, the thing that gets us is we were back here because he was originally charged back on the 16th of July last year.
Yeah, for this matter.
For this
right?
matter,
Yeah.
for the resisting and trespassing at the Auckland airport and stuff.
Yeah.
And when we showed up on the 9th of November last year to a case
A
management
hearing,
conference,
yeah.
we asked the judge for a Section 30 order to be made for full disclosure to be given within 30 days because we hadn't received a witness list. We didn't get that until May.
Oh, that's
That's
very,
like
very,
5 months
that's
afterwards.
very strange.
So, to us, if they're going to disregard the court order saying give us it all within 30 days and then supply it to us 5 months later, I think that's grounds for dismissal alone.
So that's what you can bring up in court as well.
That, in the fact that they actually supplied him the home address of one of the witnesses. The police, so they've breached the guy's the witness's privacy as well. So there's so many grounds for dismissal. It's not funny.
So that will be
But
the
anyway.
time in court when your matter is called.
Yeah. That's all right. I'm pretty good at explaining all of this.
Okay, and also, definitely recommend chatting to the prosecutor.
And that'll be all actioned and sorted out.
Yeah, I'll take that.
I appreciate your help. Thank you so much.
You're saying that 11:45? Huh? 11:45 they were trying to call the matter.
Yeah, we were just waiting to see the judicial police prosecutor about 11:30. Is Ben Murphy still working here? Or
Nah.
Did he get a smack on the hand?
Yeah.
Naughty boy.
Mr. Andree.
Yeah.
I think my sergeant.
That's what you're talking about, the police prosecutor.
Pardon? Yeah, the police prosecutor.
You know how, sorry, can I just show you something? You know how the judge was saying it's a judge-alone trial?
Yeah.
There's the email from you.
Yeah, no, we realised it was a pre-trial, which is fine.
Yeah, cool. And can we give you these documents as well?
But you can hand them
We'll
up to
have
the
you-
judge when
Oh, okay.
Oh, so I'll be bursting out.
Oh no, you have no idea. A lot of times I have to like hide my face behind the...
There's a few times I thought you were just going to keep on running.
Sorry, what did, I just saw your message, but we're in a huddle. What do you need?
The prosecutor, Mr. Hart.
Have they left?
Yeah, the is not. Is that Greg?
Oh, sorry. I just, with the bundle of documents that you had, you said you got a copy? Did you
Yeah,
say?
I've
That
only
you
got the
said-
one full bundle copy.
Have you got your own copy?
Yeah, this one here.
Oh, okay. Because I was going to say, usually the day before is too late to hand it up to the judge. So if you've got a copy, you just hand it up to him.
Yeah. That's why I printed a full copy.
But you've got one for yourself?
Well, I know what's in it because it's all in the files here anyway.
Okay, that's
I've got
cool.
the submissions that are in the application.
Yep, you've got some. As long as you've got copies to hand out.
Yeah, I've got complete copies for the judge.
Okay.
For me, I'll just stick the building.
You see the video of him getting arrested? Look it up on YouTube. I think I arrested at the airport.
That's a new one,
Yeah, it was last July 16th.
That's not like 50. I was waiting on his wife. We got up early, got the kids ready because we had two younger kids. And we're waiting in line. I understand if it's text support, but all of a sudden, because I went to Kingston and standing in line, as soon as we get up, they come up, cancel. And I played this, yeah, well, sometimes I was asking questions. It was just holding the customer services and the managers to
The whole thing that ended all was the Judicial manager telling him to go organise and she's like, if she hadn't done that, the rest of it wouldn't have happened.
So then my way of thinking, oh yeah, cool, I'll go to New Zealand.
So of course they don't get stuff up in New Zealand.
But she just organised a cabin crew.
So he did.
So I went and organised one, and I told her, I said, I organised it, and then she was like, the other staff, oh, can we help you? So I went to go to them, because I was getting no answers from the manager. I went to go, and she goes, don't serve them.
No one's serving this guy. And then he starts off by saying, I'm recording you. He goes, oh, and then 10 minutes later, oh, you can't record yet. It's like this sign here, why order the judge? Love to see a copy of that because it breaches my section 14 rights. It's under New Zealand rights, or then you've got the right to secrecy.
That's what it's awesome.
So, in other words, you can record in a public place, which is important. But and for any limitation on the rights, under Section 5, it must be demonstrably justified. So if they want to say we can't report to court, especially when it's a party proceedings against every right to keep a record of it, then they should justify that limitation by showing why. But they never do. And I think I got up here when the guys were going up the top when we first came here with us last year. I got an email because I wore my books.
I remember when you came in. It was really good.
Not court.
So if you guys want to go to the break, anyway, you're going to so 11:45. You guys have like...
Yeah, we're waiting for the prosecutor and the judicial officer.
Oh no, so I think they're going over the street. They'll be back at 11:45. I've told the judge that there has been I saw the email of it, and I've told him, and he said it's fine. He's gonna do a pre-trial hearing out of it.
Yeah, because I mean, if it was...
So everything's gonna be fine, yeah.
Yeah, cool. I mean, hopefully it's just going to be dismissed and end of today, and that's the end of it with us. Fingers crossed, but you know, the Section 30 order that we got off the judge back in November last year, when we came here to the first case management conference, the judge gave us a Section 30 order for the police to supply everything within 30 days, which meant, you know, 12th of December is when he got that disclosure, but then he still didn't get a witness list for 5 months afterwards. To me, that's that's the police giving the finger to the judge's order. It's oh, haven't they? Oh, well. They're not going to. I can't believe that they supplied him one of the witnesses' home addresses. Believe that? In their 4th bundle of disclosure they gave us at the end of May, they actually supplied the type. You know.
We can't threaten them by the judge because they've been doing all sorts of things.
Oh, it's all right if they follow the rules are there. We're just following them. But I find this because I have a friend that helps a lot of orangutan family court matters, and he's got about 10 kids back this year with their families already. And what he finds is like the OT lawyers and that they might use about 30-40 sections of the OT Act and Care of Children Act. Whereas he'll use 100 or 120 of them that they have no clue even exist because they're just so used to using that set amount. Like I say, see what you're going to deal with every day. I sympathise.
Yeah, but the court, even if the judge comes in until level 45, if I don't come in open,
it's
the
not
court
open.
can't run.
Yeah, sure.
Yeah.
So what's
So you're the key to them.
Yeah.
even if the judge comes back? So I would recommend you guys have a coffee.
We've done that.
We've done that.
And we even drive around looking for all-day parking because where's the park across
Actually, at the back.
There's no
There's
there's,
the police station at the back.
yeah, we've been round there.
It's all full up.
No, it's all full. We're just back over in the 2-hour spot across the road.
You're supposed to turn around. That was hard.
Yeah. We have actually towing companies, and now the towing companies are actually charging us $400 for parking illegally.
Yeah.
Wow.
So yeah.
Charging you guys, the court or you individually?
Individual. So,
Wow.
You should know better, you know?
Yeah, for sure.
But if you guys want to hang around, I guess we'll
It's
go
not-
to the mall, maybe.
Been there. Thank you. Ain't you? Nice of her to put that on. Getting told off by the judge 3 times already. Did you hear that, Kay? Oh dear. That other guy is classic. He was. He goes, oh, look here, you record, bro. And that was him. And he remembers my jersey. He goes, I'll come back in tomorrow and go, bro, I'll put the jersey back on for you. I'll have to tell him that before we leave. I'll see you tomorrow, bro. We learned more just sitting here talking to your stuff. Thanks very much.
Yeah.
We go and sit in the mall, we won't hear about them. You should go here, you should go there. We're not going anywhere, we're quite comfortable here. It's not raining, we're
You're just
warm.
feeding us
The
with this
sun
vital
comes in.
information that we're getting from Andree. Inside information.
That's so awesome that Ben's gone.
Yes. He might be at my tankery, mate.
No, he's not.
He's not?
No, I've been there since a couple of times. No, he's not there.
Yeah.
He might be down Pukekohe or somewhere else.
Okay.
I mean, you might say, I would say it's probably only about Wiltens. Andree Wiltens. So, yeah, so.
You know what,
We're going to deal with you gentlemen. I don't think it'll take very long, so just be patient, okay?
Yes, you're right.
So you're not ready for the certified trial today, and that you want to argue the pre-trial only.
Yes. It was our understanding it was a pre-trial application hearing only.
Okay. So your pre-trial application seeks to stay basis that the prosecution hasn't disclosed as they were ordered to do under Section 30.
Among other things, correct.
What are the other things?
Well, there was, on the submissions in support of the application that I filed today, that's everything that's happened since the 3rd of February, whereas we've been supplied 3 separate bundles of disclosure during May. There's been a breach of one of the witnesses' personal home address where the police have supplied that to us. There has been basically the constant breaches of the time frames. There's been no notice of opposition per 7.171A of the District Court rules, that they have 10 working days to object.
This is civil procedure.
Correct, yes.
Civil rules have no application.
I was talking about the District Court rules, sir.
Yes. What do they say?
District Court Rule 7.17 means they have 10 working days to file a notice of opposition to the application.
To the application to stay?
Yeah, well, the application was filed on the 3rd of February, so we were taking that would mean they have 10 working days to file an opposition notice.
Okay.
But beside the point, I mean, I think the main point is that there was no disclosure wasn't provided in any reasonable time.
Have you got the CCTV yet?
We have the CCTV. We do not have the YouTube video that they refer to in the disclosure index stated on the 17th of May this year that they supplied us. So yeah, it's if we've been supplied.
On the last occasion you were complaining about the CCTV, but you've got that now.
No. Initially, we were stating that we hadn't been supplied any witness lists. We've been supplied 6 different statements, but no witness list as per CDA.
Why do you want a witness list if you have 6 witness statements?
We don't have 6 witness statements. We have 6 statements. They're not witness statements.
What are
They are statements. They are statements by individuals as per 13.3A of the Criminal Disclosure Act. We're after 12.2A, which is the witness list. You could have 20 witnesses, but...
Mr. Key, wake up! Mr. Key, wake up! Mr. Key, wake up! Those are your witnesses.
Then why is it stipulated the difference between 12.2A and 13.3?
I have no idea. A little practical, okay? The prosecution have given you the statements of 6 people who they intend to call. Presumably they can say something relevant to the charges. I don't know. Why can't you just assume that that's your 6 witnesses? What's so hard about this?
It's not for us to assume, sir.
Why not? You think they gave them to you for some other purpose?
Well, I think it's from what I heard of the police prosecution this morning, they're calling one of the witnesses off now. They're not wanting to call one of them. How are we supposed to know that?
Well, you could work on a worst case scenario.
Fair enough.
6 of them are going to give evidence against it.
I agree, Your Honour. I'm sorry. I apologise.
So, it's incredibly pedantic to want a witness list when you have the witness statements. It's incredibly pedantic to want a witness list when you have the witness statements.
Agreed.
And you think I should stay the prosecution because of that?
No, because they haven't supplied the disclosure within the allotted time frame.
But you now say you have the CCTV.
Yes.
Right. So what more disclosure do you want?
The YouTube video that they are referring to in the disclosure index dated the 17th of May this year.
Where's the YouTube video?
Yes, sir, that's correct. That is one of the exhibits that police will be producing. However, so my understanding is that the YouTube footage...
No. So it is an exhibit that you intend to produce?
Yes.
Has it been disclosed?
My understanding, sir, was
Just
that...
yes or no?
I thought it had, sir, but obviously hasn't, sir, but I can definitely follow that up with the officer in charge.
So how long would it take you to do that?
We can ensure that that's completed within the next week, so...
Okay. So, if I allow this trial to continue,
Sure.
how long will it take to hear it?
That would depend on the prosecution's.
Well,
you know, the supply. We'd be looking at
Give me an
calling.
estimate. I know it depends on all sorts of things. Give me an estimate. For a start, can we say that you won't be speaking, the defendant will be speaking. As a Mackenzie friend, you're entitled to give him advice, but you can't actually get up and speak.
I believe speaking for him would assist in
You won't be speaking for him at the
proceedings,
trial.
Your Honour.
You won't be speaking for him at the trial. Only qualified barristers and solicitors can do that.
Of course.
Okay? But you can't give him advice. You can sit next to him and give him advice. So he'll be speaking. I think what you told Judge Forrest means that it might take a little longer. I'm not sure why you said that, but that's one of the things that I saw from the transcript. How long will it take, the trial?
I would say between 4 to 5 hours, given the 6 witnesses from the police and possible Mr. Adams and his wife as a witness on.
Even though the CCTV footage, you say, shows everything.
It shows the assault. We've also filed a counterclaim in regards to this matter as well.
There are no counterclaims in the criminal jurisdiction.
Okay. I actually have I don't have the rule in front of me. It's in my paperwork there, but I believe it's 5.15 is of the court of the district court rules.
Civil rules?
No,
Does it relate to civil proceedings, not criminal?
I may have misunderstood that, sir.
I think you might have. So there are no counterclaims.
Well, we've paid $200 for
I
to
can't
file.
believe that.
Can we get that refunded?
Oh, well, I don't know who attempted it or why, but yes, you should not be paying any money in respect of this criminal prosecution.
Right.
You may well have filed some civil proceedings,
No.
and they might have taken it on that. I don't know.
It's under the same CRO, Your Honour.
Oh, it shouldn't be. Yeah, don't give it back. You
Okay.
shouldn't be paying any money.
So we can get that refund if I go and ask the registrar.
Yes.
We will do that, and then we can take that up on the civil court and criminal matters claim.
Yes, well, that's the way to go.
Absolutely.
Definitely. So if we said 4 hours, how long? Have you got a date yet? So, possible date for the trial will be 22 September. If the prosecution give you your YouTube, CCTV footage, whatever it is, within a week, that will give you plenty of time to be ready for trial in September, wouldn't it?
Absolutely.
That's what you want. That's the purpose of disclosure.
Yes, we
So that you can be ready for trial.
want you to
But
be
it's
fully
not a
informed.
basis on which to stay the prosecution entirely.
Well, this charge was because the application for dismissal and stay and discharge was because that we hadn't been supplied within the 30 days of the Section 30 order being given.
Okay, but you got something in 33 days or something.
Yeah. We got the CCTV footage and 2 other statements from 2 other witnesses.
So you haven't got 100% disclosure, but you've got, I don't know, 80% or whatever the number might be.
Yes.
You're not too far short, and if I make them do it within a week, you'll have 100% and ready for trial.
Sure.
Okay. Well, on that basis, your application for stay must be declined. Okay. The matter needs to be heard. There's a matter of public interest in hearing criminal allegations, whether they be true or not. The courts need to deal with that. And I can't grant you a stay just because they're 3 days late.
Okay. I think the grounds was because Mr. Adams had 2 speeding tickets in January that were both dismissed because of no witness list being supplied. So we had, under those basis, they were both dismissed because they failed the 2 requisite requirements.
What I would say is twice extremely lucky and once not.
We were very pleased, I will say that, Your Honour.
All right, well, I'm declining your stay application. Is there anything else you need apart from this YouTube thing?
I'm not going to ask for that. So, wait me to win in lotto.
It's pretty hard for the police to supply that one, I think.
Hoping you can help us, Your Honour.
No, what are we talking about?
For the 22nd. Is there a particular date we must file any statements from the defence witnesses, or can that just be done on the day?
You don't need to file any defensive statement. That's a civil procedure again. So in criminal matters, you just come along and you make the prosecution prove the charge against you if they can, and you can either give evidence, Mr. Adams can either give evidence or not, and either call witnesses or not, as he chooses. He doesn't have to give any warning at all until the prosecution case is complete. So the best thing to do is to hold your fire, say nothing. Okay? What day did you do? 22 September. So I'm declining your stay application. I'm requiring complete disclosure by 4 p.m. next Friday, the 7th of July. And if not, there's a real danger of the case being dismissed. That's recorded on the file, Mr. Muller, so you know the situation. I'm sitting down a 4-hour judge-alone trial commencing 9 a.m. 22 September. Allows to continue until then. I've made a note on the file that if Mr. Adams has paid $200 in respect of this criminal prosecution, it must be refunded in full.
Thank you, Your Honour.
If you wait half an hour or so, this file can be taken down to the registry and then you can try and get it back. And you can point to this note, okay?
Appreciate that.
All right, thank you very much.